Welcome to the New York City Civil Courts Community Seminar Series. My name is Lisa Courtney and I'm the coordinator for this program. The Community Seminar Series is free and open to the public. Thank you all for attending. The topic of this month's seminar is Defenses to Residential Non-Payment Proceedings. Our guest speaker is experienced attorney Sandra Russo, Housing Law Coordinator for Legal Services of New York City. Ms. Russo will address the defenses to non-payment proceedings and will then take questions from the audience. Thank you.
Hi, I'm Sandy Russo, and I've been doing these trainings for many years for the Civil Court, and it's a pleasure to be here this afternoon, and I thank you all for coming. Let me start just a little bit with a brief description of, excuse me, an introduction to housing court itself. You're all here. This is the housing court in New York County. There's a housing court in every county in New York City, the Bronx, Brooklyn, Staten Island, Queens, and New York. The housing courts in each of these boroughs, except for Staten Island, is divided into two sections. There's something called the resolution parts, and those are several courtrooms where your case will first go. When you get a notice of petition and petition, what you may call a dispossess, you will first go to the civil court clerk's office and answer that dispossess, and the clerk then will give you another date and time to come back, and we'll go over it a little bit later on this form that the clerk will give you. It'll say the date, the time, the part, and the courtroom number to which you ought to return. And you will be sent at that initial stage to a resolution part. If you cannot resolve your case with the landlord or the attorney, then the case will ultimately go to what's called a trial part, where in fact you will have a trial, and there'll be a judge in that part who will hear the trial. Most cases in housing court are settled in the resolution parts. The vast majority of non-payment cases are settled in the resolution parts. As you may know, most landlords in New York City do have attorneys, and most tenants in New York City's housing court do not have attorneys. So many of you will be navigating this system on your own without the benefit of an attorney. I'm here today to try and tell you folks what it is you may need to know, give you some of the tools and information so that you can defend against a non-payment proceeding. By the very nature of the word defend against a non-payment proceeding, it means I am addressing you as tenants. There is the assumption that your landlord has some claim against you for rent that he or she believes is owed. I'm going to take questions at the end. I may answer your questions as I go along. The kind of case that goes on here in housing court is called a summary proceeding. It's very quick. There aren't long adjournments and delays and discovery and motion practice. Things happen very quickly in housing court. So the more information you have at the earliest stages of the proceeding, the better off you are to defend your case and raise issues that you believe are important in this proceeding. A non-payment case starts with a landlord's, generally a process server, delivering papers to a tenant. In a non-payment proceeding, in these summary proceedings, the landlord is called the petitioner, and the tenant is called the respondent. It's very much like plaintiff and defendant, only in this court, those labels are changed, and it's petitioner and respondent. Tenants are the respondents. Those papers will be delivered to you in a certain way. The law provides that they have to be given to you in a certain manner, that the process server has to take certain steps to try to find you personally to hand the papers to you. Failing to find you to hand the papers to you personally, the process server can do two other things. If there is someone else in the household who lives or works there, the process server is allowed to give them the papers. That's called substituted service. If no one answers the door after 2 tries, the process server is permitted to tape the petition or the dispossessed to the door and then must follow up with a regular mailing and a certified mailing. And they have to mail copies for every respondent named in the proceeding. The papers will have what's called a caption. It'll have the Civil Court of the City of New York, County of, and that will be the county where you live, where the property that's involved in the litigation is located. So that if you live in New York, Manhattan, you will come to this court, New York County. If you live out on Staten Island, the petition will state that the court is from Richmond County, and you will go to that court to answer. In the petition has to, once you receive it, has to lay out a bunch of facts that are very crucial to the proceeding. Remember, I said it's a summary proceeding, it's quick. So that the court knows that everything is being done properly, all the information that's necessary to the court must be in that paper, in that petition. Your name or the respondent's name, the tenant's name has to be correct. If there are more than one tenant, if there's more than one tenant and the landlord knows that, if there are 2 people on the lease, both respondents have to be named. Then the petition has to describe the property that the landlord is bringing you to court about. So it has to have the address and your apartment number or a description of your apartment, front floor, rear. If you live on the 3rd floor front apartment, then there's something wrong with that piece of paper. It's not accurately describing the property, the apartment that the landlord is taking you to court about. The petition has to include what rent the landlord says is owed, what months, what amount. There may be some other fees that will be included in the petition, late fees, a fee for making a key that you never paid. Those additional fees can be added onto a petition. But let me step back for a minute. Before even you get that dispossess, you're served with those court papers. Before that, the landlord in a non-payment proceeding is required to do something else. He's required to give you what's called a predicate notice. Before the court case starts, the landlord must first ask you for the rent that he or she believes you owe. And that demand, it's called a demand for rent. If you don't have a lease, that demand can be an oral demand. He can just call you up on the telephone and say, Mrs. Jones, you owe January, February, and March rent. And the demand has to be very specific. What months are owed? How much is the rent? What's the total owed? If you have a lease, usually there is a clause in the lease that says all notices must be in writing. So in that case, the landlord has to send you a written predicate notice or demand notice. And it has to contain the same information. You owe me so much rent. These are the months for which you owe. This is the rental amount, and give the total. If the landlord has not demanded the rent before giving you these court papers, you might ask the judge to dismiss the case because the predicate notice that you're entitled to, you weren't given. Because the thinking is, maybe if the landlord asks you for the rent and you pay the rent, there's no need for a court proceeding. Or maybe if the landlord asks you for the rent and there's some dispute, that you and the landlord can work that out without having to go to court. So this is a very important requirement that the law places on the landlord. Assuming that you've gotten the notice, and that you're not paying the rent, or there's some dispute that you feel you shouldn't have to pay the rent, you will then be served with the notice of petition and petition. It is generally a 2-page document. The front is the notice of petition, which tells you this is a non-payment proceeding. This is the court that you have to go to respond to this court case. Even if you have paid the rent, even if you have had a conversation with your landlord or your landlord's attorney in which they say, great, we have your money, don't bother coming to court. Don't bother with those papers, ignore it. I would advise you to come to court anyway and answer and make sure that the landlord has in fact discontinued the case. And if the landlord has not, come on the court date that the clerk will assign to you to make sure that the case is either dismissed or discontinued since you've resolved it. Many tenants mistakenly think, well, I've worked it out with the super or the landlord or someone in the management office, and they said, oh, it's okay and you can pay it out, and and I didn't bother coming to court. And lo and behold, several weeks later, you may be getting a notice of eviction because you defaulted, you did not come to court. So I advise everyone, you must go to court for your own safety and make sure that the case is resolved the way you think it is. As I was saying, in that petition, there has to be very specific information. Your name has to be right. The apartment that the landlord is seeking to possess, what the dispossess or the petition in these cases is asking for is, I want to recover the property. If the rent is not paid, I want the apartment back, which means I want to be able to get a warrant of eviction and have a marshal evict this tenant so that I can get my apartment back if the rent is not paid. So it's very serious. And the court takes it very seriously because it's housing. It's a vital need. Also, what has to be included in the petition is the status of your apartment. Are you an unregulated apartment? Do you live in a 1 or 2 or 3 family house where there are no regulations? Are you a rent-controlled tenant? Are you subject to rent stabilization? Is this a Section 8 tenancy or some other federal subsidy? All of that information has to be accurately included in the petition. If you're a rent-stabilized tenant or a rent-controlled tenant, the landlord also has to include in the petition that your apartment is registered with the DHCR. That's the Division of Housing and Community Renewal, the state agency that oversees those 2 programs. And landlords are required annually to register rent-controlled and rent-stabilized apartments with the DHCR, indicating what the rent is and who the tenant in occupancy is. So there are all these requirements. So you receive it. And I'm skipping over some things because we only have an hour and I want to give you a chance also to ask some questions. You get this one way or another, either personally delivered to you, you come home one day and find it on your door, and what it'll say on the notice of petition is that you have 5 days to answer in a non-payment proceeding. So what that means is take those papers with you to court, to the court indicated on the notice of petition, the Brooklyn Court at 141 Livingston Street, or the New York Housing Court at 111 Center Street, and go to the clerk's office. And there's the housing court clerk in every borough. And you present, you show the petition and you say, I'm here to respond. I got these papers. Now the law says that the landlord has certain rights. Certainly the right to collect rent if there's an agreement between you. And you don't need a lease to be bound by an agreement to pay rent. There are tenancies in New York that are called month-to-month tenancies. There's no lease. There's just a verbal agreement between you and the landlord that you will pay so much per month. If you don't pay that amount, you're not excused from that obligation because you don't have a written lease. You're required to do that, certainly if you're occupying the premises. But there are also certain rights that tenants have. And those are the rights that you should be aware of when you're responding to the non-payment petition. I touched upon one of them, which is you have to get the papers, and you have to get the papers the right way. So that if you come home and find something stuffed in a neighbor's mailbox and happen to see that your name was on it, that's not the proper way that the law says the process server has to give you the papers. And that's called a defense. You can come to court and tell the clerk, I didn't get the papers the right way. Or you can come to court and say, there are two of us on the lease. The landlord has only named one of us and only given one of us papers. I think that both people should have been named. So there's a defense that's a necessary party, someone who's entitled to be notified that there's a legal case against them, hasn't been properly notified. They haven't been named. So I've talked about what the clerk has in front of him is this document. It's called we call it a pro se answer. I'm not sure how the court refers to it. An answer form. You cannot fill it out, but this is blown up on the wall in the clerk's office, very large, so that you can read it. And you can see there are 14 defenses listed. And you can look up there and see what may apply to you. Now, another defense is, let's talk about the rent. Is this the proper rent? Maybe it's not. Maybe you had an oral agreement and for months you've been paying $800 a month. And you get the petition and it says you owe $900 a month. Well, that's the improper rent, and that's a defense to this case. The landlord is not asking for the proper rent. We have an agreement. I've paid pursuant to that agreement for many months, and now the landlord is claiming I owe some other amount. Or if you are rent controlled or rent stabilized or in Mitchell-Lama housing or other regulated housing, the rent may be wrong. Wait a second, I have a rent stabilized lease. It says here that my rent is $747.22 a month. Why does the petition say another amount? So that those are defenses. Or, wait a second, this says, and the notice I got before the court papers said that I owed February, March, and April. Well, that's wrong. I have a receipt for February, and I paid a part of March's rent that I have a money order copy for. So that a defense is, this is the wrong amount, or I paid part of what the landlord is asking for in these papers. So you have to carefully read through the documents that you get. There is another major defense that some tenants know about and others do not. No matter what kind of housing you live in New York City, whether it's a small one-family building, a lease, no lease, whether it's New York City Housing Authority, a big apartment building, fancy, a small tenement, it doesn't matter. No matter what kind of housing you live in, the law says if someone is going to rent to you as a residential tenant, the property that they rent, the apartment that they rent, must be habitable, livable. It's got to be fit for human habitation. And even if you don't have a lease, it's written into the law. If you're in the business of renting to people, what you rent to them has to be habitable, livable. And if it's not livable or habitable, then the landlord has breached the warranty of habitability. When you go and buy a television set, it comes with a warranty. It's a guarantee that this is a TV and it will work, and when you turn it on, you'll get all the channels that you're supposed to get, and you'll get sound as well as picture. And if it doesn't work, you send it back to the store and say, wait a second, I have a guarantee here. and it's not working. I want my money back or I want it replaced. Well, in housing, you can't quite say I want it replaced or, you know, I want it, you live here. So the law says that if you're not getting 100% of habitability, then maybe you're not obligated to pay 100% of the rent. And how does a judge or the law, how do they figure out, well, what's habitable? You know, someone who lives in a fancy Park Avenue apartment would find where I live not very habitable. It's not so fancy. Well, there are laws. It's not so much fancy, but there are certain basic services that have to be provided. So we know, just from watching TV and hearing the news, that the law says landlords have to provide heat in the winter. If there is no heat in the winter, or for several weeks, then the landlord has broken the guarantee, breached the warranty of habitability. And that, for you, is a major defense. There are building codes and health codes and other laws that deal with what's habitable. You cannot expose people living in residential housing to dangers. Rats are dangerous. Other vermin, if you have roaches and mice and rats, that's a defense. Now, it can only be a defense if the landlord knows about the condition. So the law says it may be that you have violations, that you have conditions that need repair, but you have to tell your landlord. And the law doesn't lay out how you have to tell the landlord. You don't have to send a certified letter, return receipt requested. You can call the management office. You can tell the super. You can write a letter. There are some conditions that landlords know about. The elevator isn't working. Well, several tenants have notified the landlord or the super that the elevator isn't working. There are conditions in your own apartment, however, that the landlord probably has no idea unless you tell the management office or the super or the landlord or whoever. So first you have to tell somebody, I have these conditions. If they fail to repair those conditions, then they are breaching this guarantee that they've given you. You're entitled to hot and cold running water all year round. You're entitled to not have a ceiling fall down. You're entitled to a toilet that flushes. You're entitled to a stove where all 4 burners work if you have a stove. If you have a refrigerator, it has to keep food cold, and your baby's milk cold, and your insulin cold. If there are sockets, and there has to be electrical supply, they can't be sparking and dangerous. You know, there can't be wires hanging from a ceiling that are exposed. There shouldn't be broken windows in your apartment, no matter who broke them. Often we hear a landlord may respond, well, you know, your child broke the window. There were a bunch of kids throwing balls and playing in the hallways. No matter, the landlord is still required to repair it. That's part of the business of operating a business of residential leasing. So that there are all these conditions that the law says must be met in order to make housing livable. If those conditions do not exist in your apartment and your landlord has been put on notice about them, then you can raise conditions. And in this answer, which you will see blown up on the wall, it talks about conditions. There are conditions in my apartment which need to be repaired and services that are not being provided. So if there is an elevator in the building, it has to work. Everyone is entitled to a locked mailbox. Another defense that can be raised in a non-payment proceeding or another kind of proceeding which is called a holdover, and I assume there'll be another training on that issue, but for now let's stick with non-payment proceedings, is you may be living in an illegal apartment. We know certainly that in the outer boroughs, in Queens and Staten Island, certainly in Brooklyn, there are apartments that landlords have converted, usually from small homes, 1 or 2 family homes, where they've put in a basement apartment. Now that apartment may not be legal. Certainly if it doesn't have 2 means of egress, a way to get in and out, it probably is not legal. That's an important fire code, that apartments have to have 2 means of getting out, so that if the fire is raging where you would normally exit the front door, you can get out through the fire escape. In a basement apartment, you are trapped if the fire is at that one entrance and exit door. So you might bring to the court's attention, this is an illegal apartment. What the law says about illegal apartments is that landlords can't collect rent until it is made legal. Now, if you had been paying rent up until this point, you can't get the back rent that you've paid, but you can certainly ask the court to rule that you shouldn't have to pay any future rent because you're living in an illegal apartment. There are illegal attics. We know of housing, and we've seen it on television, where people are crammed into rooms in bunk beds. You know, people who are poor and immigrant workers and don't know what their rights are. So all of those are defenses to non-payment proceedings.